The next matter to come before the court this morning is State of Ohio versus LaMont battle. Good morning, Ms. Whitaker.
Good morning, Your Honors.
The state has waived oral argument this morning. We are running a little early, but if you're ready, you have 15 minutes to present your arguments.
I could be ready in 10 seconds.
It beats the alternative.
Yes. Which I'm super glad I wasn't today.
We've read the briefs and we're ready to proceed when you are.
Thank you. Good morning, Your Honors. My name is Andrea Whitaker, and I am here appointed to represent Mr. Battle. The state has waived, and I'm not planning on addressing all points of my brief, so I may save some time. I'm not taking up my full 15 minutes. But there are a few issues that I wanted to come here and have the opportunity to speak with you about. I'll begin by letting you know that I won't be addressing my assignment of error number 4 because the state has conceded that in fact does need to go back. But I will touch on that just momentarily. The reason that needs to go back is because it wasn't addressed. I think that the lack of attention to detail in the sentencing and the plea here really are why we're here. The plea itself covers about 6 pages in a transcript, and the sentencing is pretty close to 2. I think that it's really the crux of the case because so many issues were never addressed or addressed in such a cursory manner as to make the plea of the sentencing deficient. I'd like to start with my assignment of error number 1 on behalf of Mr. Battle, and that is the constitutional requirements of Rule 11. And the one at issue here is that there was a failure to provide Mr. Battle with the constitutional requirement, notification of the constitutional requirement that the state has the burden to prove him guilty beyond a reasonable doubt. In the instant case, the trial court failed to strictly comply with that obligation. And because we're talking about the constitutional requirements of Rule 11, strict compliance, despite the state's brief, which seems to argue something a little short of that, is really what's required here. And what the state failed to inform him of is, what the court failed to inform him of is that the state has the burden. The way that the state spoke to Mr. Battle at the time was, the court said that if you enter a plea of guilty, you give up to a right to a trial, to a court or jury, where you must be proven beyond a reasonable doubt. Where you must be proven guilty beyond a reasonable doubt. Now the language, 11C2, requires that a defendant be advised that the state must prove the defendant guilty beyond a reasonable doubt. It is the state that has that burden, and the defendant has a right to know that the state carries that burden. When you read it, knowing what we know about how procedures go and how the state has argued it, well, we just forgot a single word here. Of course he knew that it was the state that had the burden. But the reason it's a part of Rule 11C2 and the reason it's a part of the constitutional requirements here is because the defendant is not presumed to know that the state carries the burden. The defendant doesn't know if the court is required to prove him guilty beyond a reasonable doubt. If he has some burden here, the courts, the legislature, and the Constitution require this as a mandatory notification because the defendant needs to know that the state is the one that carries this burden beyond a reasonable doubt. And I would respectfully but strenuously disagree with the state's argument here that the omission of the word state is irrelevant. It is an essential part of his constitutional rights. It is an essential part of his Rule 11 notification. It wasn't done here, and without that right being identified, his plea cannot be considered to be knowing and voluntarily made. If there are no other questions, I'll move to just a few things about Mr. Battle's assignment of error number 2. We are now into the section of Rule 11 that are non-constitutional requirements. Therefore, I would agree with the state that substantial compliance is all that's required here. But when a trial court fails to adhere to this rule without any compliance to its subsections and requirements, prejudice is presumed. There's no requirement, as the state argues here, that prejudice be shown if compliance is not met, even substantial compliance, if there is a wholesale failure to comply with the rule. And I've cited cases to support that proposition in my brief. Some of the requirements of Rule 11b that were not complied with at all, which is why we're arguing that prejudice is not required to be shown, is that there was nothing whatsoever in the court's discussion with the defendant in the plea about the effect of the plea. There's nothing in the transcript that can even be arguably said to inform Mr. Battle that the plea of guilty is a complete admission of the appellant's guilt. That the trial court also failed to advise Mr. Battle of the maximum penalty involved, that the time was mandatory, and the court only informed Mr. Battle, and again, throughout this proceeding, I think you'll see it in the plea transcript and in the sentencing transcript, the court speaks in a sort of shorthand in the terms it uses and the way it talks to the defendant. And while that may be enough when attorneys are speaking to each other, or courts are speaking to attorneys, or even when they're speaking to defendants, but not in the context of a plea or a sentencing. We cannot have this kind of shorthand that fails to inform the defendant of what's happening in this important process for them. The trial court only informed Mr. Battle that the crime of murder, in terms of advising him his penalty, the maximum penalty involved, is a special felony that calls for a penalty of life imprisonment for 15 years to the board for parole purposes. That's the entirety of his advisement to Mr. Battle on the maximum penalty involved. He didn't advise Mr. Battle that the term is indefinite, that he may not be released after 15 years, or that he must serve the entire 18 years before being eligible.
Well, according to the state's brief, we haven't read the transcript yet, which we will, but it says that the court did explain giving you the eligibility for parole in 18 years.
He refers to 18 to the board. Is the
what they say is he says 15 years to the board, and together with the firearm specification sentence, giving you the eligibility for parole in 18 years. So
what I would respond to that, Your Honors, I don't think that explains to him, to Mr. Battle, that is a mandatory period, that there is he's required to serve every day of that. It doesn't explain to him, to the board. I don't even think it explains to him what that is. So I think that there's a failure here to explain to him what the maximum penalty is, as well as to inform him of that, what the potential could be when he goes to the board, and that he could not ever get out. In fact, he starts to say, if you get out, and then he changes that to when you get out. So he's not even informing that Mr. Battle that he's only eligible for parole. He almost guarantees him the fact that he's going to get out when he says to him, when you get out, in terms of advising him of this post-release control.
Was this a plea where there was a plea agreement sheet, where there was a plea sheet?
There was no plea sheet, no. And certainly I have not seen any, nor is any referenced. I wasn't the trial attorney there. I didn't remember anybody mentioning it, but I haven't seen one, nor is it referred to in the transcript, or is it on the docket of the trial court. I would also say that I don't believe that the court's shorthand in the way it spoke to Mr. Battle informs him of the actual, that he would actually have to serve an actual time of imprisonment, that he would have to actually serve 18 years and then potentially more. Other things that were left out in terms of the requirements that Mr. Battle be informed about the potential penalties. He was not informed of a potential fine, nor was he asked whether any threats, promises, or inducements were made prior to entering his plea. So I think that on every level, in terms of the substantial requirements for Rule 11, the trial court failed to even substantially comply. And then finally, I would like to address the assignment of error number 3, and that has to do with the sentencing of Mr. Battle. As I indicated, the transcript of the sentence is a total of 4 pages, and the actual part where they're talking about the sentence here is even less than that. I believe it's 2. It's a very, very brief transcript. At the time Mr. Battle was sentenced in 2005, the statute required that court determined that a prison term was necessary, required that it should impose a stated prison term. And the trial court did not do that here. Again, this sort of shorthand. The trial court informed Mr. Battle that he was hereby given life imprisonment, 15 years to the board. That neither tells Mr. Battle that what his actual term of imprisonment is or what to the board means. That is what he tells Mr. Battle in terms of the sentence. I don't think that that informs him of the sentence. I certainly don't think that it imposes a stated prison term. He doesn't tell Mr. Battle that the prison term is mandatory. Now, the state argues that he's conveyed it by saying to the board. But again, there's absolutely no discussion or no explanation to Mr. Battle of what that means. It certainly, I don't believe, meets the requirements for 29-29-19. The court also failed to inform the defendant that he not ingest or be ingested with a drug of abuse or substance, and also necessary at that time was that prior to sentencing, he informed the offender, Mr. Battle in this situation, of the verdict or the finding of the court, and the court also failed to do that. I think that all of these arguments that Mr. Battle has raised here have to do with, it's a similar thread. There's a lack of specificity, a lack of information that's been provided to Mr. Battle throughout both his plea and his sentencing. And I think the failure to provide that necessary information to reach the necessary conclusions has rendered Mr. Battle's plea and sentence deficient, and I've asked the court to reverse those in this matter. Are there any further questions?
Thank you.
Thanks, Your Honors.
Court will take the matter under advisement, issue a written decision to both sides, as well as post on the Ohio Supreme Court website, which can be linked to through our 9th District Court of Appeals website. Thank you.
Thank you, judges.